Case number 1, item number 1 to 4. Okay. Item number 1 to 4. Item of phase number 2, item number 5 to 12.
My senior made an accident yesterday.
Item number
1. My senior made an accident yesterday.
Mr. Raut.
Car accident.
Serious injury, something like.
Serious injury, sir.
He's hospitalized.
Yesterday he was hospitalized. Evening he was discharged by vomiting and other things.
Okay, it's all right. The request made for Mr. K.K. Raut and counsel appearing for the appellant. Let the matter be listed on 19th October.
19th October.
19th October is all right?
Item number
Closer.
closer.
This is ending of September.
September last week.
September last.
September last will be very difficult anyway. Let us see.
September last.
27.
27th of September.
Item number 7, my lord.
7th.
Yes, 7. Liquidates by Friday, my lord. Right.
Friday, though, usually do not take the rate appeals.
No, requisite he will file.
Oh, you have requisite file.
He has not filed, he will file.
Once notice was
Order
issued,
also normally
but it was written observed, says notice was directed.
All right, it will come very soon. Wait, because we have to pass the order after seeing our earlier orders. Okay.
Item number 9, there are some penalties.
9 has not been called out.
By Friday already. We'll pass it, he has said that we can.
7.
Again, 9.
Item
9.
On behalf of diversity,
But you are in his chamber? Do you belong to his chamber? Okay.
The request made for Mr. Devashish Sahul and counsel appearing for the appellant that the matter be listed on 5th of October 2023.
Case 3, item 13 to 19.
Item 15, my lord. Item 15.
Yes.
Kindly proof time allowed for removal of defect, my lord. Defect is the certified copy, not right. I have applied for certified.
At the request of Mr. D.S. Sethi and counsel appearing for the appellant, let the matter be listed on 5th of October.
Item 18.
Again, we will take note. Firstly, kindly take this matter today.
Item?
18.
Take this matter today.
Already
Right.
there. Try to take up the matter.
Page 4, item 20 and 21. Page 7, item 22. Page 8, item 23. Page 9, item 24 to 26. Page 13, item 27 to 30.
My lords, item number 28. A pay for 1 week after, my lords, we just received a copy of intervention application last night, my lords. So we need to file objection, my lords.
Who has filed the intervention application?
My lords, this is regarding cancellation of lease, my lords. The sub-item number 3, my lords, in the list, allegedly the lease has been transferred to that opposite party, my lords. So intervention application, they have filed one intervention application, my lords.
Your lordships, remember this is that IDCO matter where 3 industries were granted that lease. So in the third matter, they have filed an intervention application.
Let the matter be called out. Let us survey the.
I have your lordship.
Item number 29, Miller.
29.
29, I am out of question. I just
She will call the numbers.
Page 14.
item 29, Miller.
Open the page there.
Page
Page
14.
13.
Page 14.
1.
Item number 29.
29, Miller. I pray for short adjournment, Miller.
Is a single matter or it's a
Single matter.
At the request of Mr. H.K. Rath Singh and counsel appearing for the petitioner, Let the matter be listed on 9th of May 2023. That's 9th of October, yes.
My lords, item 31.
Yes.
I am for the appellant. I have some personal difficulty for which I am on accommodation today. In fact, I am here. I have informed the other side yesterday, Mr. Budhaj Raut, I have informed personally, and also Mr. Ashok Mahdi, I have personally informed. So, His Lordship may fix up any date.
Nanda, Sudarshan Nanda Learned Council appealing to the appellant. So the matter be listed on when?
9th October.
9th October 2020.
31 to 33.
33, Lordship. It's part hard matter.
All right, you just wait. Let us see what can be done.
Page 23, item 34.
Could I mention at 12:30?
No, we are not mentioning, we'll be there.
And
Because you know that today we'll not take the big matters because the reason there is a reference. I am asking you to be wait to fix the next date. Early next date. Okay.
kindly fix it next date, any date, Lordship, next week.
When can be earliest date?
Lordship,
This matter is hard.
Madam.
So this second can be.
12, it should be 12, Tuesday, 12. 22nd, it's not been covered, because I'll take at least 1 hour. 12, can I make it 12?
So this possible 2 p.m. It will come at 2 p.m.
Yes.
My 12, in that case, only it will do this matter.
Not there till 30.
On 12, 30, not there.
They'll make it 14, then
14 to
Yes,
2 matter.
for 14 already you have fixed 2 matters.
13, Lordship, 13.
13 also.
13 will be
Two
not
matters.
there, huh?
Election matters and 2 matters.
Lordship, let me finish. Earlier they said, let
Mr.
me finish.
Kuntia, just you talk to the Advocate General, let him complete the
21.
submission.
Yes,
And the Advocate General can address us the next date.
12.
Now, let this matter be listed again on 11th of September 2023 at 2 p.m. for continuation of hearing is spotted.
My lord, 12.
12th, okay, 12th.
12.
Page 23, item 34. Page 24, item 35. Page 25, item 36 to 38.
The item number 38, that batch of matters regarding outsourcing regulation. Was not fixed. 4th 9 it has come. But that what happened after the order was stayed, initial order was stayed in the first case, up to 1 year, they were not allowed to permit.
38. Page 25, item 38.
Most of them have not been allowed to continue.
The last may take up this matter any day on after 30th, any day or 30th. But if there is 2 p.m. ballot, so that matter can be.
The 14th, there are 2 matters on that there. 2 p.m. 12 p.m. also. 15th is Friday.
15th is a Friday. Make it on 21st of 21st.
At 2 p.m.
At
21st.
Night 2 p.m.
That is item 34.
38.
38. 2 p.m. is. How late? With this matter on 21st of September 2020
Interim order to continue.
at 2 p.m. for disposal on merit. So, Mr. M.K. Kuntia and counsel appears for the appellant and Mr. B.S. Tripathi and counsel appears for the respondent. Just you read along with the analogous matter.
Wherever interim order is there, let that be continued. The other cases, there is interim order.
Interim order to continue.
Wherever it is there,
Just to check out whether the interim is there.
First case, there is an interim order. That first case interim order is continuous.
I understand by operation these are all, yes.
Because all the cases are disputed in accordance with that.
All right. The interim, just only in the first case. First
not there. Not supposed to continue.
Page 48, item 39. Page 49, item 40 to 45. Page 52, item 46.
40, 41 same era.
All right.
They're outsourced.
Okay, same date, same time.
Page 53, item 47 to 51.
Item 47, my lord. Lordship is directed to take this matter 12:30. The election petition will not take much time. But the noting has not come for 12:30.
Did they have
12:30.
12:30 or inform the council who is appearing for the
Yes, my
side?
lord.
Page number, yes, I mark. Page number 54, item 52 to 56. Page 55, item 57. Page 56, item 58 to 60. Page 57, item 61 to 65. Page 58, item 66 to 71.
Item 71. Item number 66 on the last occasion could not be taken up due to paucity of time. The Lordship has fixed it to today. I feel that it may not be also taken up today. But may I pray a little bit? It may not reach, man. May I pray my lady on Monday at 2 p.m. Here, my lord, the imposition of cost of 25,000 was there for suppression of immaterial facts, which are not material at all. One.
That it is fixed on 21st. It is item number 66. All right, Mr. Udgata, on 21st.
21st at 2 p.m.
2 p.m. already fixed one, but you are fixing it that you just mentioned on that day, we'll fix it. Let the matter be listed on such and such date. 21st. Items for hearing on disposal, for disposal on merit.
Item 71.
Yes.
Habeas corpus petition, my lord. Can it be taken at 12:30?
It will be taken up as the first item right now.
My lord, item number 67. My lord, I tried yesterday also, Lordship, the opposite party has filed contempt application suppressing the pendency of the appeal and it got disposed of also.
No, you come at 12, but inform the council for the other side.
Grateful, Lordship.
Lordship, item number 68.
68.
Lordship, pay for 2 weeks time to file the rejoinder.
Let the matter be listed on 9th of October at the request of your Mr. Sahu.
No, sir. Acharya, S.R. Acharya. Satyaranjan Acharya.
S.R. Acharya.
Yes, Lordship.
And council appearing for the petitioner. So in the meanwhile, the petitioner may file the rejoinder if any. No further accommodation for the same purpose will be provided by this court. Mr. Who is appearing for the state? Mr. D.K. Mohanty, National Government Advocate, appears for the state opposite party.
Page 59.
That is why he's paying for time for filing the joint.
Item 72 and 73. Page missing over.
My lord, may I seek your lordship's kind indulgence, my lord? I am on virtual mode, my lord. May I seek your lordship's kind indulgence, my lord, to mention a matter, my lord, which engaged your lordship's attention on 14th of August 2023, my lord. This is that PIL matter relating to closure of that road, my lord, of NTPC. My most respectful prayer, my lord, is for release and upload of the order, my lord, which is awaited.
Okay. You just send a memo, Mr. Das.
My lord, I have handed it over to the court master in the morning, my lord.
All right, you have given? One can be accommodated on Monday. Order has not been uploaded. That is
not uploaded, unfortunately.
We'll check up.
I'm deeply obliged. I'm deeply obliged. I would not have mentioned, but for the work being at a standstill.
No, it's all right.
Deeply obliged.
On the virtual mode also, my lord, I am my beg to mention.
Yes, Mr. Mishra.
WA number 2257/23. The same matter, the father's writ appeal, I have filed. You will see fixed on to 11th of next week. My lord, may kindly be tagged it up with it. I have handed over the memo to the physical memo.
All right. Same material, same.
conjoint number 2257.
Yes, it is done, Mr.
My lord, a copy may be served to the state in that.
Yes, already solved.
Yes.
My lord, pardon, WPC PIL number 26274 of 2023, my lord. I may be permitted to mention, my lord, this is a matter related to communal disharmonies of public interest litigation matter, my lord. May kindly be listed.
It will come on Monday. Give that memo. Next Monday. Next Monday. Because we are intervening in holidays. 6th and 7th. It is a single bench day. So the next division bench will be on Monday. We are fixing on that division bench.
My lord.
All right.
My lord.
But you are looking sad.
No, you are looking sad. You give me a copy so that you have soft copy on the state.
Have you served copy on the state?
Soft copy.
We have already served the copy on government.
All right, it will come on Monday. Come with all preparations.
I may pardon, there's a fresh writ filed by state. Contempt is filed. So any day next week matter.
All right, it will come. Take it in the fresh admission matter.
Matter read between 34 or 15. Lordship fixed it to 28th of August, but it could not be listed, my lord. Lordship next week any date, my lord.
Fix a date. What date can we then? Just tell him.
Lordship, this Mata matter.
Wait, please, 1 minute. What can we do? It will come on 12, Level Council.
Fresh admission matter, read topic numbers 1766 of 2023.
Next week it will come.
Next week, yes.
Your Lordship, may I convene my lord one WPC 984 of 2009, which is old matter. And your Lordship, this matter was on 31st August, but could not reach that matter. In that case, I have filed one miscase for substitution, another miscase for information, another miscase for package of
come on 12th.
Or like
Give these. It's not in release. We'll take this on some other day. Next week, any day in the next week. 14th, it will come on 14th.
That's your time.
No, this time cannot be fixed. It creates difficulty. Urgent matter where we are disposing the matter, then it's all right. So many part-time matters are fixed at 2 because for the reason that they should come at the particular time.
After rendering the service more than 12 years without hearing the petitioner, the case was disposed of, and by directing them to replace the petitioner. That's why I filed the appeal. Today I filed it. It may come
No, just wait. Today you have filed. They will check your appeal whether it is in form or not. Wait for a day at least.
Well, if that matter will not be completed, why will you discard from the?
It is a matter of regularization. Where is the urgency? We have to take time. We have to issue notice, and then they will come and we'll hear them. Wait for next week. It will be listed. No, take up now. It's personal appearance matter. One personal appearance matter.
CRLA 71.
Yes,
Lordship, this matter, Lordship had specifically adjourned to 16th of August. It was not listed on that day. The appellant and her son.
Whether it has been listed before any other bench?
No, Your Lordship, it has not been listed before. It was specifically, it was before Honorable Justice Biswanath Ratho. Thereafter, it was specifically assigned to Your Lordships. Lordships have heard it elaborately, and we were awaiting instructions from the.
Give it will come on next week any day. 14th it will come. Come not for mentioning, come for making submissions. And don't on that day say my senior is busy in another court. I will not allow it. I'm telling you, I'm very serious now.
Next on the list. So the first item will be item number 70. Item number 70. 23, madam. Passed by the Lord, single judge, madam. Here in this case, my lord, that there is an advertisement for fill-up of helper of Anganwadi center, madam. Annexure 1, my lord.
Page 10.
Yes.
My lord, there is my lord, paragraph 3, my lord.
Preference will be given to the orphan, widow, divorcee, and destitute women.
Paragraph 3, my lord, the applicants, your lordship got it. Applicants who are interested to apply for the post.
Paragraph 3.
Are requested to bring original.
You said the
page 10, my lord, annexure 1.
That is the letter number 563.
My lord.
What is the paragraph 3? Paragraph 3 is a preference will be given to the orphan.
No, my lord, that no. From the top, my lord.
Okay.
The applicants
who were interested to apply.
Interested to apply for the post are requested to bring original educational certificate, permanent residence certificate, and attested copy of documents and attend the meeting. My lord, the educational, there is no qualification, my lord, for Anganwadi helper, my lord. The education qualification is sought for determination of the age, my lord. For that, it was required, my lord. After that, what happened, my lord? I have sought for an act under the RPA Act. He has given a ninth pass of a school, my lord, and I have applied for the school about the genuineness of the certificate, my lord. Yes. That ninth class certificate.
That is what is they have written in page 12.
My lord. Page 12, my lord, annexure 3. I have given the English translation.
Yes.
My lord, no such person, no such student was reading in the school, my lord.
Yes.
So after that, my lord, I have challenged the appeal before the ADM, my lord. The ADM has stated that since there is no qualification for the post, so his education qualification cannot be looked into. So he rejected my application. My humble submission, my lord.
Whether she has given any other certificate in proof of age?
No.
Mr. Behra?
My lord, there has been no dispute pertaining to her age, only with regard to her qualifications.
But you show from your any office order that qualification is required for that post?
No qualification is required.
Then?
Hence, if your lordship sees annexure 4, page 13, this is the order of the collector.
Yes.
The additional district magistrate. Annexure 4, if your lordship has page 17.
Yes.
Only thing, was she within the age group criteria? Did she fulfill the age criteria?
I have to seek instructions on that point.
Because the learned single judge has mentioned that in his order.
There is a dispute pertaining to the certificate that she has produced.
Is it necessary? Was that certificate of any consequence? Suppose it is kept out of consideration.
Only for the purposes of age, as admitted by the appellant. The additional district magistrate notes that she was appointed unanimously by the village committee. That is at page 17, noted.
Yes. And only because of this fourth certificate, she didn't.
She is continuing present.
Opposite
party is continuing.
Continuing, madam. My humble submission, madam. If entry with a 4 certificate.
But forget about the first certificate.
My lord. My lord.
Learned single judge has said you have not challenged the age.
No, I am not challenging. I am challenging that certificate. Certificate is a fourth, my lord. I am not challenging his age, my lord.
But there is no educational qualification.
No, educational qualification. I am not, my lord. There is no educational qualification. But determination of the age, you must have to produce some educational qualification or any certificate, my lord. But he has produced an educational certificate, which is a fourth one. The school authority has stated
in support of age also. In support of her age.
Yes, my lord.
No other document regarding age.
If your lordship sees annexure 2, page 11, one certificate has been given by the opposite party, which is alleged to have been forged.
No, I have alleged. No, this is a finding that it has been forged because the letter you see
We are asking if any other document regarding her age.
I have to take instructions, but it is unlikely that there will be any other document. The opposite party can be directed to produce the Aadhaar card copy.
No, Aadhaar copy is not.
That is after issuing notice. Whether it is
after issuing notice.
That is why we are asking.
First of all, I think any coming with the government engagement, someone is approaching the government. It is itself a serious misconduct to file a forced certificate. That cannot be condoned so easily. So we are admitting and issuing notice. Mr. A. Tripathi, and counsel is paying for the appellant. I think no notice was issued earlier.
No, my lord. No notice was. First time it was.
By means of this intercourt appeal, the order dated 27th March 2023, passed by a single judge in WPC number 7915 of 2023 has been challenged. So, Mr. Tripathi has submitted that age of the opposite party and the respondent number 6 has been determined admittedly on the basis of a document which the respondents themselves have stated to be the forced stop. Admit, but the learned single judge, by holding that the said certificate doesn't have any bearing on the selection process, in as much as the said certificate is an education qualification certificate, and since for appointment for engagement in the said post, no educational qualification has been prescribed, the said forced certificate will have no bearing on the selection or appointment of the respondent number 6. Admit to be heard on merit, issue notice returnable on 30th of October 2023. Steps for notice on the serving notice on the respondents number 6 shall be taken by registered post with AD within 3 working days from today. Since Mr. Arnav Behra and additional standing counsel has appeared and we have notice for the respondents number 1 to 5, no formal notice is called for. You need additional copy. I don't think.
Not required.
All. Yes.
Item 3. Lord, this is against an interim order, but in the interim order, the stay which has been granted is an interdepartmental communication. If your lordships would just see page 17 of the brief. I'm sorry, page 46 of the brief, my lord, which was page 17 in the original writ petition.
Page in the writ appeal?
Writ appeal is 46, my lords. I think your lordships have taken up the first one, 2177 of the thought.
Yes,
yes. Page 46. Lordships go.
Just I'm getting it.
Yes.
Annexure 1.
Annexure 1, which was to the original writ petition, my lords.
Is all right. This 46, the same annexure 1.
The same annexure.
Is there any agreement or
with an outsourcing agency to provide manpower, and he had supplied 4 persons. So they have come up before the writ court challenging this,
that the outsourcing agency has come?
No,
The employees have come.
Okay.
And that too, this is an internal document which has been written by the executive to the executive by its HR.
He has no right.
So, and the source also, nobody knows from which source they got this document. And that has been stayed, which in effect extends the emergency.
Name of the person is Shurjoka Maji or what?
Yes, my lord. That is the, he is one of the outsourced employees.
All right.
So therefore,
what is the order of the lordship?
Yes, my lords. If your lordship should see, that is, it's a page 113. And 114 is the stay order which has been passed.
Have you annexed that discontinuation notice?
Yes, my lord, that is at page 46. No, my lord, since this order was passed on 31st.
Anyone who is appearing for the respondent number 1 in the writ proceeding?
Writ proceeding was filed by, I think.
Who is appearing? You have served notice on him or not?
No, my lord, notice has not. This is the first time it has come up before your lordships.
We are disposing the writ petition, allowing you the opportunity to file an objection against that prayer, and let learn a single just hear that matter.
Your lordships may fix up a time frame because the agency will continue with the option.
You go there and file the objection within 7 days.
Yes,
I ask the because we cannot direct the learn a single judge.
No, I understand, my lord.
You will also request so that if matter is taken up, but we file within 7 days.
All, if it all can be taken on priority, your lordship.
All right. By means of this intercourt appeal, the interim order dated 27 July 2023 is passed in WPC number 23136 of 2023. Heard Mr. DP Nandal, senior counsel, listed by Mr. DK Mahapat.
RK Kanun.
You have a Vakalatnama?
Yes, yes.
Listed by Mr. RK Kanun, counsel of the appellant. Mr. Nandal and counsel has submitted that the respondent number 1 was engaged, being provided by the outsourcing agency. So the appellant doesn't have any relationship as such with the respondent number 1, who is the writ petitioner, challenge the contemplated action of termination, court termination, just
of the agency agreement.
In terms of the agency agreement. Stuff. We find the order dated 27/7/2023 has directed that the discontinuation notice dated 28/6/2023.
This is not the discontinuation notice. This is the internal communication by the head HR.
That we refer what has been in the order.
Yes, I'm sorry, madam.
Dated 28/6/2023. It is directed that it has been directed that the purported italics discontinuation notice dated 28 June 2023 shall not be given effect to till the next date. We have examined the said order later dated 28/6/2023 46 at page 46 of the memorandum, you'll find it. Check the dates.
Which page?
28th June 2023, Annexure 1 to the Memorandum of Appeal, which is interdepartmental communication, even not to the agency, outsourcing agency stuff. But definitely a decision is available from the said interdepartmental communication. Unless on the basis of the said decision, any action is taken, neither the outsourcing agency nor the respondent number one can have any cause to come to the court. So, however, we will not make any observation on merit at this stage. Having considered the perspective fact, we request the appellant to file an objection, preferably within a week, against the prayer for the interim order as made by the one of the writ petition. So thereafter, we also request the learned single judge to take up the matter with expedition. So, preferably within 2 weeks from the date of filing of the objection. So far the interim relief is concerned. In terms of the above, this retail stands disposed of.
Lord, we have been paying them salary in the meantime. So they should not claim any equity on the basis of that. That may be clarified, because otherwise they will say that they are being continued without the agency being now in place.
How can the question of salary? Look, unless you terminate the respondent number one, you have to pay the salary. There is no question of that.
I'm saying I'm not saying I will not pay salary. I'm saying they should not claim any equity because of that. Because the agency has been discontinued, but they are being continued because this also had that means and mentioned for
this is a part of your submission before the learning. If any order is passed, then come again. You have sufficiently empowered the entity. Also dealing with power.
My lord, all are the same, only the pages have to be, my lord, according to that writ petition.
All are same means all
the same applications, same 4 writ petitions were filed by 4 individual persons.
But the writ is only one?
No, my lord, 4 writ appeals along with
item 3.
Oh, item 3 is below petitions. Okay. There, just see that.
So only the page number has to be changed to correspond the annexure 1 of the original writ petition.
All right.
If a lordship want, I'll ask my associate to just give a sheet of paper so that for each the page can be mentioned.
We are not mentioning page, only the date of the communication is the same.
Yes, date of communication.
We have not mentioned anything regarding page.
No, I think your lordship said mentioned at page 46.
We are passing a common order.
Yes, your lordship may only say annexure 1 of the order dated so and so. That would suffice.
Are all the all that intercommunication is it same day?
Same date. Same date.
Only thing different letters.
Different letters for individuals.
It is the same letter, no change in the date in annexure 1.
Change in date, but so far as the employees are concerned, for different, because in the circle wise,
the cost title they have separately done, but common order will be passed.
Yes, that can be done. That can be done.
Yes.
DPO.
Oh, there is a condonation of delay petition.
The first one was 1 day which was shown.
No, then we cannot take up the matter.
And thereafter it has been removed. Then the second one, it has been shown as 4 days. But we received the certified copy on 31st of August. So that has been filed within time. But the date has been calculated from 24th.
If the
when the
village-
passing of the first order. Wrongly told, but since they had pointed out as of abundant caution, we had filed the
No, if
application.
you point out that there is no delay, we
There
can
is no delay actually.
point out what is wrong with the stamp report.
Because the order, the copy we received on 31st, the communication.
Just let us check it. In first case,
no limitation is there. That has been accepted because the order was 28th and 27th of July, and then the copy was received. But in the other two cases, where 4 days delay has been shown.
Have you filed
First
this?
Monday.
No, it has been shown that it has been rectified after pointing out before the.
No, first one, there is no limitation.
Second
Yes,
one, Sanjay Kumar Sahu, they have shown 1 day.
Yes, there is no limitation.
No, there are also no limitation. The 2178 and 2180, those writ appeals, there it has been shown as 4 days.
1 day, as per the stamp report. which has
1 day,
been managed here.
my lord. That initially it was.
Can't be. This is the original stamp report. Senior counsels are not supposed to know anyway. Your associate should tell you what has been pointed out.
That's on that basis I have stated so.
That is what I'm saying. Instructing counsel should be more particular.
In the third case also, is there any delay?
I'm checking.
No, third case it has not shown anything.
No, any delay is not there. Yes.
There is no.
Fourth one,
Subsequent modification of order. What is there? Some modification of order? 7.
In the third case also, there is no delay.
no delay. The fourth again, maybe 1 day, my lord, or 4 days. 180.
2180.
2180.
What is it?
4 days delay.
Yes, maybe that is
Last.
In the second it is stated by Mr. D.P. Namdal and a senior counsel appearing for the applicant that there is no delay as such in as much as this certified copy was filed on
was received on 31st of August.
31st of August, and these appeals are filed on
28th
of August.
On 31st of July and 28th of August. I'm extremely sorry. 31st of July.
All the copies are got on the same day?
Same. They are all 4 writ appeals were all
received on 31st of July.
So filed on 28th.
31st July.
The orders have been passed on different dates.
No, earlier one order was passed which said that in 2 cases, which was modified subsequently on 27th. If your lordship should see the second brief.
And you applied on the same date?
We applied on the same date.
Okay. And the applications for obtaining certified copy was filed on the same date. That is on the day when the order was passed.
Received.
Order was received, man. Order was received by us.
No, that is the receipt on 28th.
When we received, when we received the notice, immediately we applied and then on the next day we got it.
Not on the, from the date, on the very date, the application for obtaining certified copy was filed. So this just when the applicant received the notice, meaning the knowledge of the existence of this said order. We have appealed,
the application was made the next day.
The writ appeal being
2178 and 2183
and
2180.
2023 as such is not bound by limitation. Only therefore these applications are disposed of.
Did you? Item 4, the urgent copy on proper application. May I please?
I will also not turn to page. In fact, my representation at annexure 50, page 59 is pending before the opposite party number 1, and the occasion of filing the representation arose, the lordship may turn to page 53, my lord. The type copy has been submitted. My lord, initially the BO submitted the absent statement in respect of 3 teaching staff of a girls' high school that they are not attending the school and not taking the classes. That absent statement are annexure 10 series, your lordship will get. And thereafter, my lord, immediately the same authority under annexure 11, my lord, filed the absent statement saying that they are attending the school. We sought for the information under the RTI, that is at page 53. Your lordship have a glance. He has specifically mentioned that
How it is a public interest litigation, Mr. Counsel?
because, my lord, they are not attending the school.
Where is
And they are taking.
Where is
I am that locality. I am a law graduate. I belong to that locality, my lord. It is in my locality in that school is there. My lord, here, my lord, the service condition of any employee, or it is not. Here, my lord, the fact remain, admittedly, they are not attending the school, but by virtue of this letter, now they are getting, they have already got the salary. I have, and my representation to the extent that your lordship may have a glance, page 53, that will clarify everything, my lord. My lord, that I was submitted the absent statement, I placed the staff of Chitrada Girls High School in pursuant order number such and such. Since Miss Binodin Senapati, Subhas Das and Saurabha Mahanto staff of Chitrada High School were not attended the office of BO, Moroda, to put their signature in the absent statement, their absent statement was submitted for a period from 1st of August 2022 to 31st of January 2023, showing as absent. But in subsequent event, as per the advice of Nityananda Barik, additional District Education Officer, District Education Office, Moribhanj, another absent statement in favor of above staff of Chitrada Girls High School has been submitted, showing their presence in the attendance register via which office letter number such and such, that 8/2/2023 could be a Moribhanj. But in fact, they are not attending in the office of Block Education Office in Baroda.
Yes, madam.
You're directing that on the basis of this information diverse in the thing. Or is it order?
In the representation he stated.
There was earlier writ petition.
Also to that order, my lord, annexure 15 has been
Accordingly caused an end.
I have annexed that order.
Page 58.
Also to that annexure 15 I have submitted.
What order was passed?
To approve the appropriate authority.
Page 58.
Thereafter, the BO has passed order that they are not entitled to.
Thereafter, I submitted the representation to the government. Page 59.
But thereafter that. Very strange.
Well, let's opposite panel to one take a decision on the representation.
Is it correct that the DO conducted an inquiry and found that they are not attending school? But
There is a letter that, as it appears from that letter, the lordship can find it at annexure 9.
What is this?
This 45 will permit me, I can take instruction on this matter, or that representation is pending, your lordship can take it.
No, you take instruction.
Well, I'll take instruction.
Because the officers are involved.
Yes,
but not disciplining the schools. With the request of Mr. MTL and Council, Regional Government Advocate appearing for the state opposite parties, where the matter will be listed on 12th of September 2023.
Some more time, 12th.
Okay.
14.
Okay, 14th of September 2023. Meanwhile, Mr. Kuntil and Shiva shall take instruction regarding the allegations made by the petitioner. Is one that despite in one absentee statement with 3 teachers were showing not attending the school, but subsequently such statement had been altered showing they have attended the court. So attended the school on the very days where those 3 teachers were shown absent. So then the state Mr. Kuntil Council is requested to produce the order dated No, just where is that order is coming? WBC number
24/2/2023, order of the DEO, who said that they are absent and not informed.
No. Where is the writ petition's reference?
In that, which paragraph have you stated in your writ petition?
Produce a copy of the order dated 7/1/2023. Passed in WPC number 33426 of 2022.
You will also directed to produce that order to 7th January.
That is regarding these 3 teachers.
7th January 2023. That has been annexed to the petition.
7-1 is there?
Yes, ma'am. That's page 38, annexure 9.
Page
38, annexure 9, ma'am.
For the High Court order, this is the education officer order.
Yes, ma'am. In complaint.
No, I want the High Court's order.
Yes, ma'am.
High Court order is 13/12. High Court order is 13/12.
You come to the page 60, Mr. Kuntia.
Page 37 is the order.
No, you come to the page 60. There is the representation that the Honorable High Court by order dated 7/1/2023 disposed of the said writ petition directing the DU Maribod to consider their case.
Is your representation incorrect, Mr. Lenka?
Hello?
Because 7/1 High Court has disposed of, not High Court has not disposed of on 7/1.
Since they did not attend the filed read petition, this petition has filed earlier read petition that your lordship can find it.
No, this petition. These 3 teachers.
Teachers order, my lord, your lordship can find it page 37, page 37. That my lord is looking at the WPC 33426 of 2022. Lordship can find it from page 37. And
so you in the representation you have wrongly given another order. This
no, pursuant to that order, my lord.
No, you just go to your representation,
my lord.
So if
that order is at page 58.
No, just a minute. If that order is modified, you should have stated in your representation. You should not say, give incomplete facts.
No, my lord, that order has not been modified. Pursuant to that, inquiry has been undertaken, and your lordship may get at page 45.
But where is 7/1/2023 order of the High Court?
That is not regarding anything.
He has
benefit.
They have wrongly stated that the order of the Honorable High Court is 7/1/2023.
That's what we are asking him.
It is 60.
What is this out? Regarding High Court's order, regarding the allegations made in the
Main allegation is DO has said they were absent. How could that order be changed?
That instruction I can take.
The order. Three teachers were in the repetition.
Mr. Lenka, your date chart is incomplete. Date chart is incomplete.
But by repetition,
Your date chart is incomplete. You have not stated anything about the writ petition.
date settlement.
Yes.
Three features. I'll file a straight date settlement. In the meantime,
Why are you doing this? This is to assist us. Usually time is being wasted.
the matter is listed on 14th of September 2023. Mr.
Better date chart.
Did carry some. Mr. Lincoln Council is appeared for the petitioner.
It takes to file a.
And he is undertaking to file a first date chart by the next date. First date setup. You have just asked that regarding the manipulation in the absent statement. Nothing else you look into.
That instruction I can get.
All right, next.
The client is very sincere, spending money to go after those three features. Your client is very sincere.
Just up to 67, no? Have you informed?
Yes, Lordship. Yes, Lordship. Since he was not taking phone, I gave WhatsApp message giving information in detail. Yesterday he was here. It was mentioned twice.
Yes, he was arguing a case. He was here.
Yes, Lordship. Yes, Lordship. So, Lordship, what happened? They have filed contempt petition on 14th of August.
No, that is what. Send for the council for this.
Shall I produce this message I have sent?
During court time, nobody can see, may not also see the message. That is our anxiety. Let us see.
Lordship, the only thing is, if it appeals to Lordships, only one thing I will bring to Lordships' kind attention, Lordship. They filed contempt application after the appeals notice is given to them. Appeal is a notice issue order is passed on 2nd of August. They filed the contempt application on 14th and it is disposed on 25th of August without giving any notice to the contemners. And
challenge that order.
Lordship.
You challenge that order passed in the contempt proceeding without hearing you?
Yes, Lordship, we can. But unless there is a stay, partial stay, I'm praying, Lordship.
No, the stay, why the stay should be passed in such cases?
Lordship, briefly speaking, the respondent was charged with taking some bribe for doing some favors. There was CBI inquiry, there was criminal case going on. A lot of facts are there. Lordship, let the order of the Honorable Single Judge be tested before your Lordships. Lordship, in 2 parts, he was directed to be reinstated with full back wages. So he is reinstated, Lordship. The only back wages part can be tested before your Lordship in all my humble submission. Because the public money is involved.
But Learned Council is not here today. In absence, we do not like to pass any order. Because we are upgrading the matter. No? Without notice, we are upgrading the matter. It will not be fair on our part to take up a matter all on a sudden.
Lordship. So can I in my humble submission pray before Lordship? If Lordships find it convenient to fix it at any day at 2 p.m.
That will be much better with the time. Always. That's the 21st.
On 11th or 12th, Lordship, because I'll be going back today. Yesterday I stayed. I came from.
Come again.
Yes, Lordship, I would love to come here.
Yes.
So can it be on 11th or 12th?
21st of September.
Lordship?
Possible. 21st of September.
It will be a bit late because the deadline given by the contempt order is 25th of September.
Yes, all right. You challenge that order. That is a challengeable order without hearing you. If a deadline is given by it is an appealable order.
Unfair play is done because.
It's all right. It is an appealable order in the writ appeal.
Yes,
you have not to go to the Supreme Court also.
Lordship.
Yes.
So can I pray, Lordship, any day in the next week, if possible?
It's not possible. It's really not.
If possible, Lordship.
Already you are fixing the matter on Monday, 18th. Huh?
18th, yes, Lord. 2 p.m. Lordship.
This is not the case. I think I'm 67. This one, it has been stated by NS AG Goodgutiel and counsel appearing to the appellant that in a contrary proceeding initiated by the respondent, the Honorable High Court has passed a
Yes, Lordship, I am handing up the copy of the order taken from High Court website and the detailed when it is filed.
This High Court has passed an order to comply the order which is challenged, comply the order dated 1/11/2022 in WPC number 22822 of 2020, which is challenged in this appeal by within 1 month from the date of the order. As such, next, what do you order on 25/8/2023 in COMTC number 5951 of 2023. Directing the appellant to comply the order dated 1/11/2022 delivered in WPC number 6. Therefore, it is required this matter is taken up urgently. Stop. Let the matter be listed on 18th September 2021 at 12:30 p.m. for disposal on merit.
Deeply grateful.
Just call the WPC CRL matters. Just 1 minute, we'll take up a matter because habeas corpus matter will give it really prioritizing those matters.
Item 6. That is the order. The specific order is there. The district administration is on the issue, but practically that is not on the. Rather, the order says that should stop.
Here.
Well, I have seen that.
Mr. Mahapatra, it is stated that welfare draft will get the rights.
On this.
Can it be taken up on Monday?
Monday, yes,
Mr. Mohammed, we are fixing on Monday.
Yes, yes,
in this public interest litigation, all right. He is not also pressing for the trust. He says that this minimum the essential should be provided to the children who are studying there. The petitioner has asked this court to direct the opposite parties number 1, 2, and 3 within first bracket small 1 to release the maintenance grant and rice quota of its students of Satyabhama Devi Higher Secondary School for hearing impaired Gotho Patna, and to allow the management to function for achieving its academic excellence of hearing impaired students. To direct the opposite parties number 1, 2, and 3 to ensure starvation-free survival and smooth higher secondary education of the children. Smooth higher for survival and smooth secondary education of children with hearing impairment in Satyabhama Devi Higher Secondary School with human sensitivity and humanity without taking them to any inexperienced management by affecting their right to sign language through which they communicate their feelings and daily needs through the sign language. Teachers are duly registered under the Rehabilitation Council of India.
How many students, Mr. Mahapatra?
Stop.
How many
It has
students?
been stated by
Page 21 is the sanction order. Page
Mr. D.K. Mahapatra, Learned Council, has submitted that despite the financial benefits granted to the said college.
College or school?
College, junior college.
College.
Higher secondary
School means junior college.
Satyabhama Higher Secondary School.
College, the food grain supply to the college has been suspended. In support of his contention, Mr. Mahapatra and Council with the petition has produced a communication dated 17/7/2023 as issued by the District Social Security Officer.
Yes, yes.
Stop. At this stage, we will not make any observation. At the request of Mr. M.K. Kuntiya and Council, plus election government advocate appearing for the state opposite parties, we fix this matter on 10th is 8th of September 2023. Meanwhile, Mr. Kuntiya and election government advocate shall take instruction from the appropriate authority in the government. The copy that has been served, placed by Mr. Mahapatra and Council for the petitioner is taken on the court.
Mr. Mahapatra, you're saying college everywhere, you are saying school.
That is junior college. So higher secondary school is junior college. And that means this. Let's say call it on fresh admission, although that will not be fresh.
No, this is what fresh admission.
Item 7.
Date लिख दो, page number लिख दो.
Chief, I am on behalf of RK Raut, my lord. My lord, nothing is that postal requisite not filed. I filed in 3 working days, my lord.
Okay. Item number 7.
2014 matters.
Yes, lord.
What do you want now?
My lord, I have filed requisite in 3 working days, my lord.
You have filed or will file?
Will be filed, my lord.
Oh, you'll be filing, okay.
So after 8 months or 6 months.
You are Mr.
My lord, on behalf of Ranjan Kumar Rao. My lord,
You are not there on the file.
no, my lord.
What is your good name?
My lord, Akshay Kumar Bora. A.K. Bera.
In the request of Mr. Akshay Kumar Behera, and council appearing on instruction of Mr. Ranjan R.K. Raut and council. The matter will be listed on 15 days time you want.
Yes, yes.
Okay, listed on 9th of September, October 2023. All right. It is seen from the list to note that the appellant has not filed. They recuse it for taking steps on the respondents, nor have taken any first steps for serving the notice. Okay. it is made absolutely clear that if such step is not taken, it will be compelled to pass an order for non-execution. So 15 days you take steps.
Yes,
Item number 8.
Yes.
Item 8.
Isn't Mr. Das any longer there in the panel or he's there?
Yes, yes.
Then nobody is up here.
I'm from BP. I'm BC, ma'am.
No, Mr. Mohanty, I saw Mr. Mohanty, P.K. Mohanty.
Are you Mr. Saroj Kumar Das?
We have SK Das, ma'am. His personal difficulty. Mother is illness due to hospital.
Okay, sir. Okay.
Yes. Is not 8. What is it? This one. Principal account general. Yes. Mr. Das.
No, he's not Das. I'm here.
Das is in the hospital. Mother is illness due to.
What's your name? What do you want?
My name is Pandan Mahanti. We have a.
What do you want, sir?
The next week, ma'am. Adjourn next week, ma'am.
You want an adjournment?
Delay of condition 60 days, ma'am.
The request made for Mr.
What is your name?
My name is Pandan Mahanti.
What is?
Please,
Repeat it, please.
please repeat your name again.
Pandan Mahanti. Pandan Mahanti.
Spandan.
Spandan.
Yes.
Spandan Mahanti, like council appearing instruction, Mr. Saroj Kumar Das, and council for the appellant, let the matter be listed on 11th of October 2023. Yes.
Item number 10.
This matter, my lord. When respondent number 1 has died, and we have got the information in course of the day, we are filing petition for substitution, for limitation, and setting aside abatement. 3 petitions were filing in course of the day.
Mr. Mahapatra, any objections?
Madam. I have no objection, madam.
All right. What has
As respondent number 1. Others are pro forma respondent.
it has been reported to this court by Mr. Pradipta Kumar Mohanty, senior counsel appearing for the appellant, that the respondent number 1 already that the details of the respondent number 1 who had passed away in the pendency have been collected, and a short adjournment, if a short adjournment is given, the appellant will take steps for substitution. Questions allowed, let the matter be listed on 11th of October 2023.
My lord, 10, 13, 14 and 14.
Just a minute, Mr. Pratap Kumar Mahapatra appears for the year for the respondent number.
He's dead.
Dead.
Dead. Is present before us. Stop. Mr. Mahapatra was appearing for the respondent number 1. Stop. What is the other matters?
Other matters, the first matter, the impugned order, that is just complete in other matter. That's a covered matter. Only 4 to 5 lines that it is covered by that order. So that is why 10, 13, 14,
Notice.
48 and 49. Your lordship last time directed to tag all the matters.
All right.
But has notice been issued or not?
No, notice had been issued in limitation matter.
10, then
others are appearing also.
10, after 10, which one?
10, 13, 14.
14 and
14, 49.
48 and 49.
9.
Okay. Please make this. You have the order first, this matter is on such and such. Okay.
I have already informed the other council. He is agreed for that. He is there in other cases.
So item 11. Item 11, there are two.
So he got neck. He got.
Is this state appeal?
Yes, Malli, this is my. But two interim applications are there. One for condemnation of delay, there is 29 days delay, my lord.
Who is appealing to the appellant?
The notice has been issued.
No, let us see what is the office note.
Reproduction not received.
Upon the note of the registry dated 28th March 2023, it appears that the notice which was issued and the respondent by registered postweek AD has been delivered. So the tracking report has been placed in the report. As such, we observed that the service is complete. Let the matter be listed. Let this appeal be listed again on 11th of October 2023.
11th of October. All the two cases are covered by my last judgment also. In that Joseph Barry case, relying that Joseph Barry case, your lordship has also decided the issue last week one matter. It can be subject so that matter can be disposed of.
All right.
These matters are covered by this judgment.
All right, 12th of September.
Well.
So any other matters there related? 28.3.
47. Given the date, order date or in the next day.
Yes, just say.
Page 7.
This is not the date. This is adjourned to 5/7/2023.
Date at the bottom, which is signed and put a date 4/7.
Oh, so what is the system? Is there?
First they mentioned the date number on the market.
Instead of 28th March, you make it 4th of July 2023. No? Same. 12th of September.
12. Item 12.
12 was similar?
Similar, my lord.
Same order.
Item number 16.
What about 13? It's over.
13, 14 just now covered. Item number 10.
Okay.
Right.
Right.
Item 16. Yes. In item 16, my lord, notice has been issued on 2nd May 2023.
It appears from the registrar's note that Mr. Shamir Kumar Das, Land Council, was employed into the for the respondent But today when the matter is taken up, there is no representation from the respondent.
Well, his name does not appear in the cause list.
16.
His name does not appear in the cause list.
So the reason for such non-appearance may be that the name of Mr. Das, Land Council, has not been reflected in the cause list. List is directed henceforth to reflect the name of the Mr. Shamir Kumar Das as the counsel of the respondents and the cause list without fail. Mr. M.K. Kuntia, and counsel has appeared for the appearance number 1 to 4. Date is given? No. But the matter is listed on, it can go 11th of October 2023. Yes. Oh, yes. What is the case? Alpha number?
47.
Proceed now.
Now, please, Your Lordship.
Yes.
But this appeal is directed against the order of the learned, judgment of the learned single judge, reversing the order of the election tribunal, allowing an application for amendment of the election petition. But before I take Your Lordship go to the merits of the case, if Your Lordship sees the last order passed by this Honorable Court, the question of maintainability was raised on the basis of a full bench judgment of this Honorable Court. The full bench judgment, my lords, is.
Have you annexed that anywhere?
That is 2008, volume 2, Orissa Law Review, page 725. There it was held that against a judgment passed in a writ petition under 227, an intercourt appeal would not lie. But my lords, first, after this judgment was delivered in 2008, this judgment came to be considered by a division bench of this Honorable Court in an election case. That's reported in 2019, volume 1, OLR, page 1037. Beta copy there.
It is already there in record.
Were Your Lordships in this judgment, in paragraph 5, will find that this full bench judgment has been taken note of.
Yes.
And thereafter, my lords, in paragraph 9, the court formulates the questions. Para 8 is relevant. My lords, may I read out paragraph 8?
Yes.
The next question this court has to address is whether the mode of deposit. Sorry, my lords. The conclusion is in paragraph 7. Sorry, my lords. Very sorry, my lords. In paragraph 9, the court has summarized, relying upon a judgment of the Supreme Court, the court has summarily extracted paragraph 45, which is there. Thereafter, in paragraph 6, it says, in applying this principle to the case in hand, this court comes to the conclusion that the returned candidate has filed this petition under Article 226 and 227. The basic difference between Article 227 and 226 statutory jurisdiction is that Article 226 is intended to keep the lower tribunals and courts within the bound of their jurisdiction. The scope of Article 226 is wider. In AIR 1955, page 233, in the case of Harivishnu Kamath versus Syed Ahmad, the question came before this court whether the decision of an election tribunal can be challenged under Article 226 or not, wherein a 7 judges bench of the Honorable Supreme Court has addressed itself to the question,
whether the High Court has jurisdiction under Article 226 to issue writs against decisions of election tribunal. Then Honorable Supreme Court has laid down that the article confers in the High Court the power to issue appropriate writs to any person or authority within their territorial jurisdiction in terms absolute and unqualified. The election tribunals functioning within the territorial jurisdictions of the High Court would fall within the sweep of that power. Keeping in view the aforesaid three authoritative pronouncements, this court is of the opinion that the writ appeal is maintainable against the order passed by the election tribunal on a proceeding of election disputes under Orissa Gram Panchayat Act. This is an election petition under the Panchayat Samiti Act, which is absolutely parametric to the Gram Panchayat Act. In this particular case, what has happened is, if your lordships will take page 13, which is part of the election petition, page 13 of the brief. Yes. Paragraph 4. That while the voting process was going on, unfortunately, all of a sudden, it was a petition. Sorry, yes, Madam. This is the election part of the election petition. Okay. That while the voting process was going on, unfortunately, all of a sudden, opposite party number 1 insisted 6 PS members of so-and-so, 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 so-and-so Gram Panchayat, who were very much hale and hearty on that date, represented the election officer, that is opposite party number 2, that they are not capable to cast their votes and thus their representatives be permitted to cast their votes on their behalf, to which the present petitioner and some other voters objected. Thereafter, your lordship takes my application for amendment. Application for amendment is at page 26 and 27. I wanted proposed amendment, your lordships will find at the top of the page. I propose to change the names of 3 of the villages because this is information which I got earlier in respect of the names of some of the Gram Panchayat was wrong, and hence I wanted to change the name of 3 of the villages out of the 6 which I had named. So that was the only amendment which was sought. And thereafter, this amendment was allowed by the election tribunal. That order is at page 30, page 31. Amendment petition was allowed, which was assailed by the successful candidate before this honorable court, and the judgment is at page 34. Your lordship may take page 37. This is the where the court has committed a jurisdictional error, which I am assailing before your lordships. Yeah. Page 37, paragraph beginning reading together. As your lordships note, page 37. Yes, page 37. You are going to paragraph 4. Paragraph 4 I was referring to in the election petition, but thereafter I had shown to your lordships. So yes, this is part of paragraph 4. Yes, the paragraph beginning reading together above both the above paragraphs. The paragraph starts with considering the rival contentions. Considering the rival contentions of the parties, I am just reading out the relevant portion, where the jurisdictional error has come in. Reading together both the above paragraphs, this court finds mistake committed through the pleadings in para 4 cannot be considered to be a simple typographical error. Keeping in view that the contesting opposite party herein moved an election petition, it is unbelievable, even though the petitioner is making his ground involving malfunctioning in an election petition giving wrong description of the villages. For the opinion of this court, the mistake appears to be inherent mistake by allowing change in the village names after election dispute period is over, which will be amounting to extending filing of election dispute beyond the same stipulation prescribed in the Gram Panchayat election rules. Finding the election dispute involved inherent mistake. An amendment being brought after 15 days restriction from filing the election dispute of this nature is impermissible in the eye of law. This is the jurisdictional error which has been committed by the learned single judge, because the court feels that if the amendment is allowed, it would be tantamount to extending the period of limitation, which is 15 days, beyond that. But that is not the case, Maharaj, because what the law has been propounded by this honorable court. I will firstly take your lordships to a single judgment of this honorable court, which is your lordships must take paragraph 5 to begin with. If your lordships have got paragraph 5, may I read it, Maharaj?
Yes.
Learned counsel for the opposite party, on the other hand, contends that the second proviso to section 31 of the Orissa Gram Panchayat Act confers a discretion on the learned civil judge junior division to condone the delay in filing the election petition beyond the period of limitation if the election petitioner satisfied the court about existence of sufficient cause that prevented him to file the petition within the period of 15 days. He further submits that since the decision in KD Das Supra is not under the Orissa Gram Panchayat Act but under Representation of People's Act, which does not contain any provision for condoning delay for presentation of election petition, the said decision will have no application to the present case. Now, that was the case of the Gram Panchayat Act.
Yes.
Which provides for a condonation of delay. The Panchayat Samiti Act also provides for condonation of delay, which is not there in the Representation of People's Act. Next, your lordship will take the paragraph at the bottom of that page. Paragraph beginning, it is apparent from the aforesaid provision that though a period of 15 days from the date of publication of the name of the elected person has been provided for filing of election petition, the second proviso confers a discretion on the civil judge to condone delay in presentation of a petition beyond the set period. If the petitioner shows to the satisfaction of the civil judge there was sufficient cause for his failure to present the petition within the prescribed period. No such provision like that of the second proviso to subsection 1 of section 31 of the Gram Panchayat Act is available in the Representation of People's Act. Therefore, the decision of KD Deshmukh cited by the learned counsel for the petitioner will have no application to the present case. Paragraph 7. Since, as per the second proviso of section 31(1), an original election petition can be entertained if the petitioner satisfied the scope by showing sufficient cause for his failure to present the petition within the period of stipulated 15 days, there is no reason as to why the said provision shall not apply for introducing a new ground of challenge to the election of the returned candidate by way of an amendment in the petition originally filed within time. And here I am now bringing in a new ground. I am just changing the name. In his amendment petition, the opposite party has clearly stated that the disqualification of the petitioner from holding an office of profit as a lecturer in the Indira Gandhi Mahila Mahavidyalaya, which is undisputedly an aided institution, was not within his knowledge at the time of filing of the election petition. This assertion of the opposite party has not been disputed or challenged in the objection filed by the petitioner to the amendment petition. Though the court below has not specifically stated to have been condoned the delay in entertaining a new ground by way of amendment, but it has taken note of the fact of lack of knowledge on the part of the opposite party about the disqualification of the petitioner at the time of filing of the original application. If a fresh election petition challenging the election of the petitioner on the new ground of his disqualification can be entertained by condonation of delay, the trial court has appropriately allowed the amendment by way of incorporation of the new ground in original application to avoid multiplicity of proceeding. So, the order committed by the learned single judge that it could not, that since that 15-day window was no longer available, the amendment could not have been allowed. is, in my humble submission to your lordship, an error of jurisdiction committed by the court, because the reading of the statute, which has already been done by this honorable court in this judgment, clearly indicates that even a new petition with a prayer for condemnation of delay could have been filed.
Yes.
So in that view of the matter,
Question, let us see the provision.
yes, my lord. The provision, my lord, the Panchayat Samiti Act. Section 44. Volume 14, बताइए. ग्राम पंचायत एक्ट that is the section. Page 379.
Yes.
What?
379.
379 of the referring to the book where the Panchayat Samiti Act is.
379, yes.
Panchayat section 44B. Presentation of petitions. The petition shall be presented on one or more of the grounds specified in section 44L before the Civil Judge Senior Division, having jurisdiction of the place at which the office of the Samiti is situated, together with a deposit of so and so, for costs within 15 days from the date on which the result of the election was announced. Provided that if the office of the Civil Judge Senior Division is closed on the last day of the period of limitation as aforesaid, the petition may be presented on the next day on which such office is open. Provided further that if the petitioner satisfies the Civil Judge Senior Division that sufficient cause existed for the failure to present the petition within the period aforesaid, the Civil Judge Senior Division, knowing his discretion, condones such failure. Now, your lordship sees, if your lordships were to compare the provision of the Gram Panchayat Act, which has been extracted at paragraph 6 of the judgment which I had just placed, it is absolutely parimetria to that, except that that petition is required to be filed in the court of the Civil Judge Junior Division. This is in the court of the Civil Judge Senior Division. So otherwise, it's an identical provision. And this provision has been read by this honorable court and interpreted. Was to mean that an election petition could have been filed, a fresh petition could have been filed after 15 days by condoning delay. So there is no difficulty in allowing an amendment to the election petition to bring in a new ground altogether. Now here there is no new ground except that the names of 3 of the Gram Panchayats, that's also again another committed error of the face of the record is that he has taken them to be 3 villages. It's not 3 villages, it's 3 Gram Panchayats, which are constituencies under the Panchayat Samiti Act. Yes. And 44F of this Act provides, my lord, the provisions of the civil procedure codes will apply to the trial of the suit. 44(1), my lords. 44F(1). First audit अच्छी प्रथम bullet in fact, on the question of jurisdiction also at the first instance, representation of which it already said, also we repeat it. So, my lords, I would sum up the submission.
Should know whether such application was filed before the election tribunal.
The application for amendment I have just shown to your lordship's knowledge. That's at page. That's at page 26, Manoj. Wherein I have filed the application and order 6 rule 17 read with section 151 of the CP code. And the proposed amendment which I have sought for is at page 27. And this was allowed by the election tribunal. Let me sum up my submissions by submitting for your lordship's consideration that this appeal is maintainable because what is being assailed before your lordships is arises out of order passed by the election tribunal who had allowed my application for amendment, which was reversed by the learned single judge on the basis of a jurisdictional error where he wrongly erroneously read the provisions of section 44F. Section 44, 44H. 44H of the Panchayat Samiti Act. And hence, my lord, the amendment which has been sought for is absolutely necessary for the proper adjudication. There is no new ground being taken. So it will not prejudice the defendant in any, respondent in any manner. And hence, I pray the amendment be allowed. That's all. 44B. 44B. That's all.
Okay. My pleasure, Lordship. My lord, I am appearing for respondent number 1, my lord. My lord, so far as maintainability of writ appeal is concerned, the law is well settled in the full bench decision of your lordship, as referred by my senior, my lord, in 2008 volume 2, Weller full bench, where it has been stated that the judgment order decree passed by honorable single judge in exercise of power of a superintendent under Article 227 of the Constitution of India is not amenable to letters patent appeal, my lord. My lord, which is confirmed by the honorable Supreme Court and attained finality, my lord. There is no review after that order, my lord. My lord, thereafter also, in several decisions, honorable apex court as well as this honorable court held that, including in 2015 volume 2 LR, Jogendra Singh ji, Vijay Singh ji versus State of Gujarat, held that an order citation, my lord, 2015. 2015 volume 2 OLR.
You Supreme Court, other citation, parallel citation you don't have.
Only Weller reference I have bring, my lord.
That is referred to, my lords. In fact, that is referred to division bench judgment which I have cited.
Always.
My lord.
This is Jogendra Singh ji versus State of Gujarat.
My lord, State of Gujarat, my lord.
2015 9 is 60.
My lord, in that case, honorable appeals court held that an order passed by civil court can only be assailed under Article 227 of the Constitution, and once it is exclusively available, exercisable under Article 227, no intra-court appeal is maintainable. My lord, the honorable appeals court also observed that if an application filed under Article 226 and 227, what is important to be ascertained is the true nature of order passed by the single judge and not what provision he mentioned while exercising such power. My lord, your lordship kindly appreciate the impugned judgment. My lord, running page 38 of the briefs, the honorable single judge
in paragraph 6, concluding paragraph, held that perusal of reasoning assigned in the impugned order.
Mr. Counsel, just a little bit. That little bit that you just wait for this, come to the decision as cited by Mr. Mukherjee. In this, in Subhasis versus Bhandepatra. In para 8, you come the.
I have not
annotated there. Para 8, don't have. There also, they have another decision they have reproduced, the Shashwati Patra versus Saraswati Biswal and others. That is a 2002 OLR 3. I am just relevant part for your benefit. I am just pointing out. Principally, the judgment appealed against falls under Article 226. And a statement made by the learned single judge that he has exercised power and that he cannot take away the right of the appeal against the judgment. So these judgment, if relied on, we have to find out what jurisdiction in fact
single judge exercised. That is why I have pointing out your lordship to the impugned judgment, paragraph 6, concluding paragraph.
Come to this paragraph 6.
Perusal of the reasoning assigned in the impugned order for the support of a law of land to case of the petitioner and for clear restriction involving limitation bringing such a dispute. This court records that there is casual attempt by the trial court in considering such amendment application, particularly involving election dispute. For there is mechanical disposal of the amendment application and allowing such application in illegal exercise of power, almost involving an attempt to extend the filing period of election dispute even there having no such power. This court interfering in the order under at Annex 5 set aside the same in the result petition disposal. My lord, here the honorable single judge set aside the order impugned and no further ancillary order passed which can be exercised passed only exercising Article 226. Here the order confined to Article 227 set aside the order impugned passed by the court below. Hence, there is no
order that has been set aside with the learned single judge.
My lord, order passed under an application under Order 6, Rule 17, allowing an application for amendment.
And learned single judge set aside that order.
Yes, my lord. Only set aside that order.
All right, that's all?
Yes, ma'am. As far as the limitation part is concerned, in the application for amendment, there is no prayer for condonation of a delay and no separate application for condonation of a delay, and the plea that the proposed amendment it is my lord, material fact which change the nature and character of the suit, my lord, which cannot be introduced by way of amendment. The honorable single judge has dealt with it categorically in that aspect, my lord.
Okay. We'll pass the order later on. Okay. No time to dictate now. Other matters, Courtmaster will provide the dates.
Beg your pardon, my lord. Item number 58, and that was posted today to be taken at 2 p.m.
But because of the change of these program, that cannot be taken up.
My lord must provide a short date at 2 p.m. so that it will be easier, because the court managers are without any job and
I understand. It will be on 22nd. It will come on 22nd of September.
2 p.m.
Friday. No, it's a Friday.
Same problem.
My lord.
On the 21st at 21st September at 2 p.m.
My lord, I love this.
My lord.
37, my lord.
My lord, in item 67, there are some defects, so I shall cure by the day next date.
That order has been passed once. Why are you standing up now, learned counsel?
That is open to you. You don't have to take permission of the court.
Lord.
Item
Yes.
37, my lord. Interim order is till today.
37.
Item 45 also, my lord, interim orders to be continued.
37 and 45.
Yeah.
45, maybe taken up bit early, my lord. In the month of September, the regulation matter, my lord, petitioner, most of the petitioner was of retirement, my lord. It will only take 20 minutes, my lord, for.
So, 10 years, they have not only 10 years of service. 2007 they were appointed.
Three petitioner was of retirement, my lord.
When do they retire?
When the file the
Next year. Next year they'll retire.
Well, they are till today they have not been regularized, my lord.
That is why it will take up the matter. Item 35, no?
45.
Here is a first item is 37. Oh, this is interim order. Oh, all right. 37 list the matter again on 9th October 2023. Men who are interim orders passed earlier shall continue the council.
Same order is 45.
45 also, Mr. Deva. All right.
Also sent September month.
All right. It is 123
also sent.
1st of September. 21st of September.
Item 53. Same interim order is still today.
No, same as what? This is a regularization matter.
No, not regularization.
Then say, don't say same. All right. What is that item number?
53.
53, same order.
Item 22, my lord, a matter related to Sisuvan, a lordship director of the Land and State Council to file an affidavit. Time and again they have taken adjournment where they have not served the copy till today also. Item 22. Sisuvan case.
He has filed the affidavit.
No, not at the file, my lord.
With copy not supplied means what?
No, my lord.
And then you say the file or not?
How does someone tell? The lordship director to serve the copy in advance. And time and again they take an adjournment.
First, they have to file it, and before that, they have not filed it. Is item number
22, my lord. A matter related to Sisuvan. Or may I pray, my lord, short date kindly fix, my lord.
Maybe taken up some of the tables. Corner file.
Listed 25th. 25th October 2023. Meanwhile,
an affidavit has been filed on 4th September 23 through e-filing.
Meanwhile, the affidavit has been filed on 4th September 2023. Copy of the affidavit is filed on 4th September 2023. It is supplied to Mr. Who is appearing for the petitioner?
And my lord, I am Mr. Mahanti is also there, my lord.
Yes, Mr. A. Mohanty, counsel.
I am also appearing 1583.
All the counsel for the petitioner. Within 7 days from today. All right, if you the petitions are given power.
May I pardon, my lord?
Plus, another date may can be fixed so that I will call the personal appearance of the
25th.
Wait, what? Two matters if you mention.
No, that is not. You
Wait, one at a time.
Maitri Shangshud matter. 25th. And within 7 days, copy will be supplied. And if you want to file any additional affidavit or rejoinder, they are filed by the next day.
My lord. Item.
Can you inform Mr. Mahanti to serve copy?
Yes, 2 days from today, copy will be served. The petitioner made file the rejoinder.
Response. The general must already be there.
Response to the state from the affidavit filed. Opposite witness, take up who has filed the
Item 33, there will be continued virus, which is a part-third matter. But let it come on 11th or 12th minute. But it has been fixed to 12th. Well,
so it's not 12th.
item 35. 35. Can it come next week sometime?
35 will be taken up 25th September.
Item 17. Item 17.
Personal opinion.
Again, call the personal. Item number 17 is a state appeal.
Honorable single judge order or challenge?
Challenge with the stay order passed.
No, delay contract.
Forget about it. Come on 9th of October 2023.
My lord, item 23 interim order till today.
23 list on 25th of September 2023. Meanwhile, the interim order is 20 past and it shall continue.
Obliged.
71, madam.
It was nothing directed for personal appearance of the appellant. The appellant number 2 is directed to Winter and the appellant number 1 is present in the court. The memo.
Item number?
How come
Who died? Zulachur died. Who died?
What someone pledged that. Which is not one of appellant. There's certificate of this basically file balance.
Korea alias Sushil Kumar Balwant.
So you have also verified?
No, I have not verified.
Because this is not a death certificate by the Gram Panchayat. So you'll have to. Have you given him a copy?
Copy seen by the
Not given. Absolutely.
So appellant 1 is present.
Well, appellant number 1, Trilochan Mahapatra is present.
The party plan council that appellant number 2
Sushil Kumar Balwant. Yes.
Kulin alias Sushil Kumar Balwant. When expired?
As for the date, 25, 25/5/2000. Mr. Tripathi, you have to state, when did he die? 19. এই ব্যক্তি তারিখ এতিকির দিন ডাক্তার এতিকির মৃত্যুবরণ।
Yes, I think in the last
25/5/2014।
This also the reference of judgment. What is the death certificate? I mean,
Panchayat has given.
I want to this has died on 28th August. Mistake of
I beg pardon, my lord, item number 8.
25/5/2014 ତାରିଖରେ ଡାକ୍ତରଖାନାରେ ମୃତ୍ୟୁବରଣ ହେଲା। ଲେଖିଦବ ଡେଟ୍ ଟା 25/5/2014।
As per ours,
as per the Sarpanch Jamkia Gram Panchayat.
Whether we passed any order to appear the appellant number 1?
Yes, shall also pass the order. By order dated 4/7/2023. 4/7/2023.
Scan है so it's not.
Hey, paragraph 2 notes.
Paragraph 2 notes 71. Just
Order not with me, so I can't help.
Sorry. Not there.
56 minutes.
That's a filer office.
The appellant number 1, Tilu Elias Trilochan Mapatru, has appeared before us. So let the matter be listed again on 11th of October 2023. Meanwhile, Mr. J. Kotokiel and additional government advocate appearing with the state shall verify the report about death of the appellant number 2 from the concerned police station. Whether these you are appearing for the appellant number 1.
Both the appellants are appearing now.
But where this by the order, this one legal aid counsel was directed to be this. You are not there.
Did you not appear before the court on that day?
No, she was not appearing on the last occasion. Unfortunately, that is the reason why.
No.
You undertake to appear, we'll dispense with his personal appearance.
This court is unaware whether, in terms of the said order dated 4/7/2023, the Secretary Orissa High Court Legal Services Committee has engaged in a counsel of not less than 10 years of experience to appear on behalf of the appellants. Sorry. Even there is no note. This party just this. So now we are not unaware. Huh? It appears that in terms of the order dated 4/7/2023, one Mr. Ramachandra Behera has been engaged by the Orissa High Court Legal Services Committee. But that counsel is not present when the matter is taken up. This will direction to not Ramachandra Behera or Purna. Purna Chandra Behera. Can we read also the Ramachandra Behera? Purna Chandra Behera. All right. The registry is directed to reflect the name of Mr. Purna Chandra Behera in the cost list. However, MS
BL Tripathi.
BL Tripathi, learned counsel who had been regularly appearing for this appellant, is present today. Stop.
I will pardon my lord, item 18.
Take up the order.
The appellant number 1 stands dispensed with for the time being.
Item number 18, my lord. Item number 18. Today it was for consideration of the interim order. Can your lordship kindly take it on 9th or 8th, my lord?
8, there is no bench. Only single bench will be available. So it will be on Monday or Tuesday.
11th or 12th, my lord? 12th.
Huh? 13th it will be taken out.
Item 65.
No, your number is 17.
18. My number is 17.
18.
18. Item 18.
18. Responsibilities. Indeed.
My lord, I have given item 18.
We have not taken up the matter. Item number 18. Yes.
65 item. Short that stay is there.
I am a state appeal, my lord. We are for the opposite party, my lord.
All right, it will come on 25th of September.
I beg to pardon, my lord. Item 17, state has filed the appeal. Interim order is there, my lord. So I told, I have appealing for the opposite party.
What did you mention once?
17.
It will come on 9th October.
I will pardon to make mention only item number 26, non-availability of safe drinking water, my lord. This is a very serious matter and very urgent.
25th September.
25th, no, other day. Another matter has already been fixed by your lordship, but other day.
27th of September.
Always, my lord.
Pardon to mention, my lord, item 37, name of the advocate of Mr. R.K. Biswam may kindly be reflected.
Sorry, item 37 is going to be reflected for name of Mr. R.K. Biswam appearing for which party?
Respondents.
It will be respondent. The request to check out. The vocal is there.
It is not definitely not called out.
Next.
My lord, pardon to mention, item number 60, my lord, fixed to 2 p.m. That's the matter of date, any other date, man.
This is not before this bench. So records are not there.
Only date we fix only.
Why don't you understand? The matters are not before this bench.
On the bench, may I call it?
Presentation item number 1.
Item.
Yes.
Yes, my lord. My lord, annexure 1 is pending before the opinion 2, my lord.
Yes.
For consideration.
CJ PIL in service matter. And your lordship can see the representation. Well, he has stated that those persons are receiving the block grant since 2015.
What is your grievance? Why you were affected on the release of grant related on these?
Well, against the illegality committed by the authorities, the representation filed before the opinion 2.
It appears you are pursuing your personal litigation.
My lord.
This cannot be the subject matter of PIL. That is why we are not passing any order. If you do not withdraw, we will dismiss the petition.
With liberty to file appropriate application.
No, we will not grant any liberty.
Find out whatever there.
Yes. At the request of Mr. Aurobindo Saul and counsel appealing for the petitioner, this petition styled as public interest litigation stands disposed as withdrawn. Yes.
Item number 2.
In this case, my lord, the petitioner has filed this item challenging the action of the opposite party, more particularly the opponent number 3, in allowing the non-technical person in technical post discharging the duty of technical in nature, my lord. Therefore, my lord, the ESI beneficiaries have suffered a lot, my lord. Your lordship can glance. I have got under the active act, my lord. Annexure 2, page 21, the qualification of prescribed for the post, my lord. Page 21, your lordship.
Yes.
Class 12 with the science and DML with 1 year experience, desirable qualification is bachelor degree in medical laboratory science, my lord. The essential qualification for the post, my lord. Now, my lordship has got under the active act, page 22, one the right side, my lord. Srimati S.C. Ekka, who had only, my lord, 7th class.
Now, what is the suffering?
Suffering, my lord, ESI beneficiary each and every month deducted their contribution towards it. Now they have a non-technical person, those are not minimum appearing the qualification. As such, there is a difference.
How that is related to distribution or taking out of the contribution? Your allegation is somebody unqualified.
Somebody, all
These persons particularly unqualified should not have been appointed. How that is got?
no, not appointed, my lord. They are not appointed, my lord. They are allowed. They are not appointed. They are appointed and accordingly, they are mercy orderly. They have been discharging duty. Your lordship can annex 5 so that the government of India will also issued a notice, my lord. Annex 5 page 41, my lord.
Suffering for this, even assuming that they have some or not matching the qualification requirements. Then what is the suffering? How?
Sometimes they have report. Your lordship, Annex 6. They have committed a mistake. They orderly nursing orderly discharging the duty of junior medical officer. As such, the HIV report has been given. Lord. Annex 6, the complaint report, which are inquired by the HOD of the laboratory department, and find that after written evaluation of the state affairs, that it is found that the demands of so and so persons are true. As headquarter number so and so, who nursing orderly so and this case, Dasik and so were promoted as laboratory and posted as to other thing.
Are you reading Annex 6?
Yes, my lord.
Page
43, my lord. The inquiry report.
No, 43. Okay.
43 is my inquiry report findings.
That is pursuant to patient grievance.
Patient grievance, my lord. Because, my lord, there is a technical post. Junior medical laboratory technology did that.
Who are you?
My lord.
Who are you? You are association.
I am an association, my lord.
Of the employee.
Yes, no, not employee, my lord. I am a social organization, my lord. I am a social organization, my lord. Annex 1 is my registration number. The central government already decision, my lord, and implemented Annex 5 not to allow the non-technical person in technical post, my lord. Annex 5.
What is the PIL procedure?
Yes, my lord.
Before coming to PIL court, you should approach the competent authority.
Yes, Annex 4, I have given notice, my lord.
This is given notice. Annex 4 is pending.
Yes, my lord. Large number of beneficiaries, my lord, deprived to proper treatment diagnosis from the ESI hospitals, my lord.
Who is appearing for the central government?
Yes, my lord.
ESI has a panel lawyer.
Panel lawyer, my lord.
Mr. Padi, are you appearing for ESI?
Yes, the Union of India Party, we are acting.
Oh, Union of India, but it's a complaint lodged before the Director General Employees State Insurance Corporation.
Yes.
They have panel lawyer probably.
No, they have panel lawyer, and the Union Party, we are appearing for all. Central government already decent.
So in the said report dated 2nd February 2022, the head of the department, laboratory department, ESI Hospital, Pinna, has observed interval year as follows, quote, page 43, last part one paragraph. After a detailed evaluation of the state of affairs on 30/12/2021, it is found that the grievances of IP Smallest, Emmanuel Sammat Kumar, Sam Ravi, and Kotesh BT are true as per the HQ order number 97 in first bracket MA close the bracket dated 1/12/2021 for nursing orderlies Jagadesha KS, Dashik N, Kamala N, and Sumo L were promoted as the laboratory assistants and posted to ESI Hospital, Pinna. They have reported in the laboratory and working in the capacity of laboratory assistants when the above incidents occurred. Unquote. According to Mr. Das, not only these two employees whose name has been referred, there are several others without having technical knowledge are handling the laboratory test in different layers. So in that perspective, the petitioner on 15th February 2023 served a notice on the Director General of the State Insurance Corporation, ESIC, No, you're not. Pinna is though in Orissa. Pinna in which state? Karnataka. Miller? This is a report regarding the hospital. It is in Karnataka. Report of the hospital, Miller? No, Pinna. What is the place?
Taking place, it is in Karnataka.
Karnataka.
Then how
this court can exercise its jurisdiction?
Odisha also, another person is continuing. Odisha also made a complaint. Annexure 6 series. Odisha patient also complained, Miller.
Where is that complaint?
Yes, Miller.
Then why are you taking support of Annexure 6?
Yes, Miller. Annexure 6 Miller, I'm at page 46. Page 46, Miller. One Prashant Kumar Lenka, residing in Basant College, Odisha, he has also made a complaint. Report as again. She made a complaint, Miller.
Scroll out.
Page 46, Miller.
I thought it is a place in Orissa.
And this was a complaint hardly on 9/5/23, page 47, by one individual.
Yes.
Why this association is pursuing now?
Association, Miller, I am registered association, Miller.
Whether he has authorized you to take
no, Miller. It is a public interest. This is a large number of people, Miller. Therefore, Miller, I am doing the association. I filed the larger interest of the beneficiary, Miller. Not my personal interest is not there, Miller.
Just keep it. Stop. In the course of the submission, it is surfaced that the inquiry is related to the state of Karnataka. However, Mr. Das has pointed out that one Prashant, his name is Prashant. Prashant Kumar Jaina,
Prashant Kumar
has also made a complaint regarding this similar affairs on 9th of May 2023. According to the petitioner, the opposite parties did not take any action as expected. Stop. Having appreciated the materials placed before us, or the Director General is a central authority, we can we direct the Director General, Employee State Insurance Company Corporation Limited, to look into these aspects and take the appropriate action forthwith. Stop. We find there is a prima facie material, materials that in violation of the recruitment rules, those person has been engaged as a laboratory help. Stop. The petitioner shall be informed by the Director General what action he has taken within a period of 3 months from the date when he would receive a copy of this order. Mr. P.K. Pari, Learned Additional Deputy Solicitor General of India, has appeared for the opposite party number 1. Since we have not passed any adverse order, we prefer not to issue any notice. In terms of the law, it is disposed of.
Already disposed of.
There is a cross-jurisdictional issue, so we have not gone into the merit. Only Director General is an All India authority.
Yes.
To him, he reverted the matter.
We are appearing for 1, 2, and 3.
What?
One is also Minister of Labor.
1 and 2.
1 and 2.
Okay, two is the
Minister of Health and 3 is the Director General. For Regional Director, they have a separate panel.
Lord, one thing, Lord, say, I pray. Taking to Annexure 5, my Lord. Consider my regards taking to Annexure 5, my Lord.
What we have stated.
Annexure 5, the government letter, my Lord. Central government letter.
Mr. Counsel, you just stop here.
Yes.
Center, this petition is misdirected. We have placed the materials, the Director General looked for, because there is a central authority, you are passing the order.
Yes,
it is happened in a regional level. This Mr. P.K. Pal, the Solicitor General of India, has appeared for opposite parties number 1, 2, and 3. A copy of this order be supplied to Mr. Pari, Deputy Solicitor General, for onward transmission.